today's video, we discuss when fee splitting occurs, specifically medical fee splitting, including doctor fee splitting in California. Many healthcare startups ask this question. So do physicians and other licensed healthcare providers. The whether and when fee splitting occurs is especially of concern to business people who want to start a medical spa, a telemedicine operation, or a health and wellness app or software platform, and involve medical doctors. My name is Michael H. Cohen, and I'm founding attorney of the Cohen Healthcare Law Group. We've advised hundreds and hundreds of healthcare entrepreneurs and healthcare clinicians and business people just like you on questions involving medical fee splitting. Today, I'll explain what constitutes fee splitting, when fee splitting occurs, what's the difference between fee splitting, a kickback, and violations of Stark. First, what is medical fee splitting? Medical fee splitting occurs whenever a physician, splits their fees with another person, say the front desk person who's managing their operation. Let's think about it this way. Let's say you start a healthcare venture, for example, a telemedicine company. It could be teledermatology, telehealth wellness checkups, telemedicine for sleep, fertility, or some other condition. You create a software platform and an app where your users or customers can contact a network of physicians and get medical or wellness consults online or via the app. The user essentially becomes a patient of the doctor. The user, a consumer, pays you a fee for the service, and from that fee, you pay the physician. Could this be considered fee splitting? It could. An enforcement authority could see this kind of scenario as you essentially taking the professional fee and splitting that fee between you and the medical doctor. When we talk about fee splitting, we're usually talking about state law, not federal law. Federal law is relevant where you have a federal payer, such as, for example, Medicare. Yet even where there's no Medicare, and perhaps not even commercial insurance, for example, you just have a cash arrangement, then state law prohibitions against fee splitting can still apply. Second, let's talk about fee splitting versus a kickback. Fee splitting, as we said, involves a perception that you are splitting the doctor's fee between the doctor and the business arm or separately incorporated business, say the telemedicine software platform company. A kickback involves a scenario in which a licensed healthcare practitioner, let's say a dentist, nurse, psychologist, or chiropractor, pays money for the referral. So if you take the same arrangement we just discussed, the consumer pays the company $100 and the company pays the doctor $25, that could potentially be considered fee splitting of a professional fee of $100 into $25 to the doctor and $75 to the software company, and it could also be viewed as the doctor giving the company a kickback of $75 for the referral. Stark is something different. Stark refers to federal law, and the basic concept is that the physician refers the patient to an entity in which the physician has a financial interest. We call this self-referral. Under federal law, some of these self-referral arrangements are prohibited. For example, the licensed medical doctor cannot refer the patient to a clinical laboratory in which the physician has a financial interest, say where the physician owns shares. Now, the Stark prohibitions apply to a list of what are called designated health services, or DHS. States also have laws that mirror Stark. For example, California has the Physician Ownership Referral Act, or PORA. When you get a fee splitting question, you typically also would want to review whether there is a potential violation of prohibitions against self-referral, as well as whether there is a kickback. This whole area of law is called fraud and abuse and gets enormously complicated with exceptions to the self-referral rules and safe harbors to the anti-kickback prohibitions. And as healthcare lawyers, we also have various structures we can use to help mitigate enforcement risk, where we feel the goal is to create a legitimate enterprise to deliver healthcare services, whether it's a brick and mortar like a medical spa or an online like mobile digital health venture like telemedicine. Among these, we might, for example, be able to structure the user fee as a fee for using the telemedicine company's software platform. This takes knowledge of healthcare law as well as understanding how to draft an appropriate agreement between the company and the user, which sometimes gets tucked into the terms of use. One of my healthcare attorney colleagues analogizes knowledge of healthcare law to knowing a foreign language. It can take years and years to build up your vocabulary, and you learn not only the basics, but also somewhat arcane and esoteric passageways through the vast labyrinth of rules that govern health and wellness enterprises. Sometimes you need street smarts and street talk. At other times you need Shakespeare. And at other times it's more like lawyered diplomacy. Healthcare regulation really is a labyrinth, and you don't want to get eaten by the Minotaur, that creature of Greek mythology that feasted on those who were tossed into the labyrinth and lost their way. No, 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 you don't want to have some regulator or private plaintiff feasting on you by way of an action involving stark anti-kickback or fee-splitting prohibitions, or some other area of law, such as corporate practice of medicine or HIPAA. We get deep into the weeds of some of these areas on our healthcare and FDA law blog at cohenhealthcarelaw.com blog. We go even deeper with our clients when we do an initial legal strategy session. Some people use the term compliance, but I find that boring. No one wants to spend their life checking a bunch of boxes. I think more in terms of risk assessment and risk mitigation. We have a 3-step process. 1. Understand your business model so we can issue spot, troubleshoot, and grasp the issues. 2. Provide you with initial recommendations during a legal strategy session. 3. Do a deeper dive so you can know the legal pitfalls and guardrails, navigate successfully. Thanks for watching. If you still have questions, click on the link below, cohenhealthcarelaw.com/contact, to send us a message or book an appointment. Here's to the success of your healthcare venture. We look forward to speaking with you soon.